Hi, it's Mark Atchley. I'm a bankruptcy attorney in Arizona. Today we're going to talk about reaffirmation agreements, what they are, and why we do them. When you file a Chapter 7 bankruptcy and then ultimately go on and get your discharge, all your dischargeable debts are wiped out, including the personal liability on your car loan and your mortgage. A reaffirmation agreement is basically a new promise on an old debt. You eliminate the old debt in the bankruptcy, then turn around and sign a new contract in which you agree to take back that personal responsibility. So if you default on your car loan after a reaffirmation agreement is approved by the court, the lender can sue you for the deficiency. Back in the olden days, before 2005, we used to do what we call a ride-through. I'd file a Chapter 7 for my client, and unless the car lender was offering us something good, like a reduction in the contract interest rate or a reduction of the principal balance, we would not agree to reaffirm the loan. If my clients wanted to keep the car, they'd simply continue making the car payments and all was well. Eventually, they finished paying off the loan, the lender would release its lien, and my client would have a paid-off car. However, if for some reason they couldn't make the car payments or if the engine blew up, they'd return the car to the lender without any penalty because, of course, the original car loan was discharged in the bankruptcy. Then in 2005, the creditor lobby, through Congress, passed the current bankruptcy code called the Bankruptcy Abuse Prevention and Consumer Protection Act, even though there was no real evidence that people were abusing the previous bankruptcy code, and even though it really has no protection for consumers. At any rate, included in the new code was a provision that requires bankruptcy filers to sign a reaffirmation agreement with the lender if they wanted to keep the collateral securing the loan. This means that if you don't sign a reaffirmation agreement, the lender can consider the loan in default and repo your car even if you're current on payments. Most lenders won't do this because really they'd rather have your money than the car. However, Ford Motor Credit and a couple other lenders used to repossess vehicles years ago if there was no signed reaffirmation agreement, even if the payments were current. In recent years, they've kind of backed off on that policy, probably because it doesn't make any financial sense. In any event, your loan can be considered in default simply by not signing a reaffirmation. In Arizona, state law says that on real estate, the lender cannot consider the absence of a reaffirmation of the home loan a default. So bankruptcy judges in Arizona will not approve a reaffirmation agreement on real estate unless there is a good reason to, like a reduction in the interest rate or principal balance or some other favorable term. Real estate lenders don't typically offer these favorable terms, and as a result, reaffs on real estate are pretty rare in Arizona. I believe, and I think most Arizona bankruptcy judges also believe, that reaffirmation agreements on vehicles are not in your best interest. You file a bankruptcy to get relief from your debt and then turn around and sign right back up on a new debt? I'd much rather you simply continue to pay on the old car loan that will discharge in the bankruptcy, so if you can't afford that car anymore or if the engine blows up, you can turn the vehicle back to the lender and owe nothing. So in order to get there and get back to the pre-2005 ride-through, the local judges have done a kind of workaround. Here's how it works. My clients get a reaffirmation agreement from the lender and then sign it and return it to my office. There are a couple places on the reaffirmation agreement form where the debtor's attorney is supposed to sign, which says that I represented my client in the negotiation of the reaffirmation agreement and that the agreement does not impose an undue hardship on my client and some other stuff. I don't sign the agreement, but I send it off to the lender who files it with the court. When the court sees that I didn't sign the reaffirmation agreement, this triggers a hearing which both me and my clients need to attend. The hearing's usually pretty short, and the judges schedule a bunch of reaff hearings all at once, so that they usually only have to explain how things work once. Then the judge calls our case, and I'll review the terms of the reaff on the record. I'll then say that because of the long term remaining on the loan, or the crappy interest rate, or my client's tight budget, this reaffirmation agreement is not in my client's best interest and could potentially be an undue hardship and burdensome. The judge will then say, I agree. And then, depending on which judge we have, the judge will either issue a Mustafi order, which is an order that prohibits the lender from repossessing the vehicle if the debtor stays current on payments, keeps the car insured and registered. Or, some judges simply vacate the hearing without approving or denying the reaff. Same result, one way or the other, the reaffirmation agreement was not approved. The upshot is, the law requires you to sign a reaffirmation agreement if you want to keep the car. So you did what was required of you by signing the reaffirmation agreement. It's not your fault the judge didn't approve it. So we effectively get back to the old ride-through. You make your payments and keep the car insured, you get to keep it. When you pay off the loan, you get good title. But if you miss payments or decide you want to get in a better car with a better payment, you can return this vehicle to the lender and you will owe nothing, because the agreement reaffirming the old loan was never approved by the judge. This is the result that we like. There are potential downsides to not getting a reaffirmation agreement approved, one being that the lender might not report your current payments to credit reporting agencies. But there are other ways to build your credit after a bankruptcy. That's another video. Also, your lender will likely not grant you any access to their online portal, so you'll need to send out a check for your monthly payment. And finally, you will probably not receive statements from your lender, so you'll need to call in and get your balance. I believe, however, that wiping out your personal liability on the loan and avoiding any kind of deficiency in the future in case you turn the vehicle into the lender is totally worth the inconvenience. Thanks for watching. I'm Mark Atchley.